Hello, I'm Riley. Welcome to another episode of Case Brief, brought to you by the Missouri Sheriff's Association. Before we get started, I want to remind everyone that this information is for training purposes only and in no way is to be considered legal advice. Today, we focus on a U.S. Supreme Court case involving geofencing and requests for data. Our goal is to provide a clear understanding of how such cases unfold. Remember, this content is educational and not legal advice. So let's dive into the details. On May 20th, 2019, a man robbed a credit union in Midlothian, Virginia. Local police officers learned from witness interviews and surveillance footage that the robber had approached the credit union from a corner of an adjacent church while appearing to talk on a cell phone. But they could not find out anything more, and the robber remained at large. On June 14th, the police officers applied to a Virginia magistrate for a geofence warrant directed to Google, which would require Google to hand over data about the cell phones located within a 150-meter radius of the credit union, the so-called geofence, near the time of the crime. The application described the cell phone location data Google collects through a service called Location History, which records the location of a user's cell phone every 2 minutes or so. The application also explained how that cell phone location data could help identify the robber, possible accomplices, or additional witnesses. The warrant described a 3-step process that the police would follow. At Step 1, Google would produce anonymized location data for all cell phones within the geofence 30 minutes before to 30 minutes after the robbery. At Step 2, officers would attempt to narrow the list, and Google would provide additional anonymized data for that narrowed list, consisting of cell phone locations both inside and outside the geofence during a 2-hour period surrounding the robbery. And at Step 3, officers would further narrow the list, and Google would turn over identifying information, including names and phone numbers, for users on the final list. The magistrate issued the warrant, and through this process, Google ultimately produced 3 cell phone users' identifying information, including petitioner Okello Chatrie, whose location data showed that he entered the geofence about 10 minutes before the robbery and headed toward a residential area immediately after leaving the bank. When the case reached the Supreme Court, the court did not decide every issue surrounding geofence warrants. Instead, it focused on one core question: whether obtaining this Google location history data from Google was a search under the Fourth Amendment. The court answered yes. That answer matters because once something is treated as a Fourth Amendment search, officers must analyze it through the normal constitutional framework. The legal question is no longer whether the technique is simply useful or technologically available. The question becomes whether the search is properly justified, sufficiently particular, and narrowly executed. The court's reasoning relied heavily on Carpenter versus the United States. In Carpenter, the Supreme Court held that the government generally conducts a search when it obtains historical cell site location information, often called CSLI. The reasoning in Carpenter was that location data can reveal the whole of a person's physical movements and therefore expose a detailed picture of that person's life, associations, habits, and private activities. In this case, the court concluded that Google location history raises at least the same privacy concerns, and in some ways, even stronger ones. The court pointed to 3 main reasons. First, Google location history can be highly precise. According to the court, it may record a device's location about every 2 minutes, often within a relatively narrow range, and in some situations may even estimate elevation. In practical terms, that means the data may show not only that a person was at a building, but potentially where within or around that building the person went. Second, the data is retrospective. Officers can look backward and reconstruct movement without having identified a suspect in advance. That is a powerful investigative tool, but it is also exactly why the court viewed the information as constitutionally sensitive. And third, the court described Google location history as something many users would reasonably regard as their own personal archive of movement. The fact that the information is stored by Google does not, by itself, erase the privacy interest in that information. The government argued that the third-party doctrine should apply. Under older cases, information voluntarily conveyed to a third party may lose Fourth Amendment protection. But the Supreme Court rejected that approach. The court reasoned that ordinary use of a smartphone and related services does not amount to meaningful consent to unrestricted government access to a detailed record of a person's movements. That point is especially important for officers. The fact that a private company possesses the data does not automatically mean the Fourth Amendment drops out of the analysis. Just as important is what the court did not decide. The court did not hold that the warrant in this case was valid. It also did not hold that all geofence warrants are unconstitutional. Instead, it sent the case back to the lower court to analyze whether this particular warrant satisfied the usual Fourth Amendment requirements. Especially probable cause and particularity. That means the major legal fights are not over. Lower courts will now have to wrestle with difficult questions such as these. Can probable cause justify sweeping in every unknown device within a geofence at the first stage? Does a multi-step process give too much discretion to investigators and too little control to the magistrate? Is the geographic area too broad? Is the time window too broad? Does the warrant explain clearly enough why evidence of the crime is likely to be found in the requested data? These are not academic questions. They are the issues most likely to determine whether evidence survives suppression litigation. For officers and agencies, the operational takeaway is straightforward. If you are seeking historical Google-style location data through a geofence process, assume you are asking a court to authorize a search under the Fourth Amendment. Draft the application that way. Keep the geographic area as narrow as the facts reasonably allow. Keep the time window tied closely to the offense. Explain clearly why relevant evidence is likely to exist in that specific data set. And if the warrant uses multiple stages, spell out each stage carefully so that the magistrate, not the investigator alone, defines the scope of the search. So the bottom line is this: the Chatrie decision does not outlaw geofence warrants across the board, but it does establish that obtaining Google location history through a geofence warrant is a Fourth Amendment search. From this point forward, law enforcement should treat geofence requests as high-scrutiny search tools. They must be justified carefully, described narrowly, and executed exactly as authorized by the court. If there is one final takeaway to remember, it is this. After Chatrie, a geofence request for Google location history is not simply a data request. It is a search, and it should be handled that way from the beginning of the investigation. Thank you for joining us in this episode of Case Brief. We hope this analysis provided valuable insights into requesting geofencing data. Stay tuned for more episodes brought to you by the Missouri Sheriff's Association. If you enjoyed this content, please like and subscribe. We look forward to bringing you more informative episodes in the future.